Welcome everyone to our September webinar. We'll go ahead and get started. My name is Cody Farzad and I'm the Vice President of Employer's Choice Screening. And I want to introduce everyone to Anthony McLaren with Adley Law Group. Very excited to have Anthony join us. He's going to be giving a legal perspective. Adley Law Group is a nationwide law firm, and mainly prime focus is to help businesses in employment matters and issues impacting these small businesses or large businesses as well. Anthony has a very long and extensive CV that would probably take the whole hour to go through. So I just want to go ahead and introduce him, and he could give you a little bit more information about his firm and his background. So Anthony, do you want to say hi to everyone?
Sure. Thank you, Cody. Good morning to everyone who's listening to us this morning. My background is in employment. I do employment management side work, primarily California. Small to mid-sized businesses are my clients, private clients. I'm also admitted to practice law in New York and the U.S. Supreme Court. I've been practicing employment law since I finished law school in 2003. Majority of what I do right now are wage and hour compliance issues, class action defense, Private Attorney General Act claims on wage and hour matters, as well as defend my clients against sexual harassment, which is a renewed topic over the last couple of years, discrimination, retaliation, etc. My preference is to give my clients counsel about how not to get into trouble, because if you find yourself in trouble and you're contacting me, that's going to be a much bigger problem. So I also do counseling, employment handbooks, and do things that will help insulate my clients, hopefully, from being sued, although the expression goes, you can sue the Pope for $100 in this country, and that's just the American system. So anyway, Anthony McLaren, and nice to talk to you.
Thank you so much, Anthony. So this is our disclaimer. Anthony is here to give his legal perspective and not really his legal advice, but I will provide his contact information at the close of the presentation. So if anyone has additional questions offline, they could reach out to Anthony. And speaking of questions, there's kind of two ways that you guys can deliver your questions. We usually leave about 10 to 15 minutes at the end of the presentation to address any Q&A. There is a chat feature at the top of the Join Me, the little bubble there, that you could put in any questions or concerns, comments throughout the presentation, and again, we'll address it at the end. You could also go ahead and email me at the email address here, and I will go into my email and pull off any of the questions that you guys may have. So we'll go ahead and get started. Again, this is our disclaimer, so we not provide any legal advice, but Anthony has been able to set time aside to be able to provide his legal perspective. And here we are right here. And real quick about Employer's Choice Online and Employer's Choice Screening. We are a nationwide consumer reporting agency providing compliant, expedited employment background checks, everything from criminal backgrounds, drug testing, and physical, civil searches. And we are a nationwide company. We do have a training division as a value-added service that could provide employee training, and we could definitely provide, compliant background checks, and that's what we're going to be talking about today. The background screening industry is very fluid and always changing. We are constantly having to keep our clients abreast of new laws and keeping them in compliance with federal and state law, especially those California clients. New laws are coming out, it seems, almost every month, or at least, in January and July, that employers need to be aware of, and these laws are impacting employers with just even one employee. So we'll go ahead and get started here. The three items that we're going to be addressing are the three-headed monster that we're going to tackle today is going to be Ban the Box and Fair Chance Act laws, which every day it seems like a new Ban the Box or Fair Chance Act law is coming out. We're going to address Equal Pay Act, specifically salary history bans, and that's verifying previous wages or asking about previous wages, and that's to address the pay gap between males and females. And then medical marijuana is going to be the third topic in talking about recreational medical marijuana and juggling both federal law and state law. So, Ban the Box, Fair Chance Act, where we're at right now. Currently 31 states, and I'm sure, Anthony, maybe 2 or 3 have been added since we've been talking. The District of Columbia and over 150 cities, counties have adopted some form of Ban the Box or Fair Chance policies. Majority of the laws right now affect more public, state, city employers or employees, but a lot of them now are coming out with private employers as well. And again, those number of private employees could be anywhere from 1 to 5. So it's not just affecting large enterprise companies with 1,000 or more employees. So small businesses, even more than big businesses, need to be aware of where they're located, where they're operating, if they're in multiple jurisdictions, and if they are subjected to any Ban the Box or Fair Chance Act, depending on where they're operating their services. The main component around Ban the Box is essentially banning the box on the employment application where you ask about any previous criminal activity. So traditionally, you would, on an employment application, hopefully written something like, have you ever been convicted of a felony or misdemeanor conviction within the last 7 years? And employees would have an opportunity to disclose any convictions they may have. What was happening was employers were taking a look at what they were disclosing and, frankly, not wanting to hire them, not even doing the background check for simply having a criminal background. And essentially, as this grew, there's a certain class of people who were being discriminated against for simply having a criminal background and not being able to be hired. And having a criminal background was a barrier to employment. And if they're not going to be able to be employed, what's going to happen? They're just going to continue to reoffend and not be a protective member of society. So that's kind of what spearheaded Ban the Box. The whole philosophy or the whole theory behind it is to really consider the applicant's qualifications and what they could bring to the company before asking about any kind of criminal activity and then deeming them disqualified just because they have a criminal background. Do you want to add anything to that, Anthony?
So, yeah, what I want to add kind of as an overview about the presentation, my dad once said to me, there's 2 things that you don't ask a man about his life. You don't ask him why he went to the doctor, and you don't ask him how much money he earned. And I think that for this presentation, we could add, you don't ask them why they went to jail. As far as Ban the Box, why they went to jail inquiries, did they go to jail, why they went to jail, just a little bit of information that you may or may not find interesting. This actually started in Hawaii in the late 90s. There was a movement there by that state to prohibit these kinds of inquiries. And it was pretty silent for a while until the 2008 recession time period. And at that time, it really began a movement, a strong movement for governments primarily to not inquire. And the rationale behind it is you do not want to disadvantage people from potentially getting an opportunity to sit in a room with you and try and get a job. And the implications of that are, can be appreciated. There's a disproportionately high number of persons that have a criminal issue associated with racial background and that sort of thing. So if you were going to require them to disclose this in advance, you were basically going to de facto discriminate against groups of people, and that's not fair to those groups of people. So people should be given the opportunity to, put their best foot forward before they're inquired of. That is kind of the philosophy behind the Ban the Box concept. And something else to be aware of, Fair Chance Act is actually California's description of Ban the Box, because I was looking for why is it called Ban the Box / Fair Chance Act, and just so you know, and my understanding is about half the people listening to us are California employers. The Fair Chance Act is the one that Governor Brown signed into became effective January 1st of this year, which was a very comprehensive ban the box approach. So California adopted what had already been going on, as Cody said, in a number of states, municipalities, cities, etc. But that is the Fair Chance Act. And California, of course, trying to lead the way and show the country about how it's done, they made it prohibitive for 5 or more if you are an employer and you have 5 or more employees and as a private entity. So, of course, the government entities in California, this applied to them, but California said, hey, if you've got 5 or more employees, you're going to be prohibited, and that follows the Fair Employment and Housing Act requirement where discrimination laws generally apply against people with 5 or more employees. So that's kind of an overview.
Thank you, Anthony. The People's Republic of California, you got to love it. All right, let's get into it. So momentum for these policies has grown exponentially, particularly in recent years. I published a recent Ban the Box map last month that had, over 500 different Ban the Box laws, all contradicting each other. We would love to have, in a perfect world, a federal preemption or a federal Ban the Box or Fair Chance Act, but frankly, it's not happening. So it's very fluid. It's always changing, and please look out for a new revision of that Ban the Box map as well. Certain class of applicants were being discriminated against, again, like Anthony and I had discussed, by purely having a past criminal record and just having bright line policies. Anyone convicted of a felony in the last 10 years is automatically disqualified. It's not going to fly anymore. The EEOC was very aggressive in coming after employers that had these kind of blanket policies, and good luck to any business that's going to be able to be operating with that kind of a background screening policy. The main component of the law is to wait until a conditional job offer is made before asking about previous criminal activity. Basically, you have the job application, you take a look at the job application, you maybe do a phone interview, or you have the individual come in and interview, everything looks good. You then decide that you're going to extend a conditional job offer contingent upon them passing the background check. And at the point that you give them the job offer, that is when you can ask, hey, as part of our hiring policies or practices, we do employment background checks on everyone that comes through our door. Is there anything in your background that you feel would potentially come up on the background check that you want to discuss? And you could either have them put it in writing or have a conversation with them. But it needs to be done when you are extending the conditional job offer. Now, not all of the Fair Chance and Ban the Box laws state during the conditional job offer. Some of them say during the first interview. So you get the job application, you then have the person come in to interview, and during the interview you could say, hey, as part of our hiring practices, we do employment background checks. Is there anything that's going to come up that you feel would prevent you from being hired? So it's really important to identify if you are subjected to a Ban the Box or Fair Chance Act law based on where you're operating and what the components of that law is. Is it during the interview process, or is a conditional job offer needs to be made? I would say for consistency purposes, and if you're aligning yourself with a competent, expedited, but compliant background screening vendor, I would do the conditional job offer. What do you think?
Yeah, so I'll just dovetail off of, jurisdictionally, the laws are different. California has its laws, and any one of these 31 states or municipalities has its own laws. So it's quite possible that you become an expert on Ban the Box requirements and limitations in your own state. I use the term expert loosely, but if you do anything enough, arguably you can become an expert. And that's great, and I applaud you for that. However, there are always circumstances, factually speaking, that are unclear. And so, your best course of action is to have someone who is an expert in that law, your labor counsel, for example, who can at least look and give you a qualified, competent legal opinion about what he or she thinks you should or should not do under the circumstances. And, of course, try and anticipate this problem before you even have the interview with someone. Have periodic conversations with me or your attorney about, have there been any new changes, Anthony? What do I need to know now? I'm operating in the city of Long Beach. Has Long Beach adopted any new things that are different from the city of Los Angeles or from the county of Los Angeles or from the state of California, etc.? And that is how you can best insulate yourself from problems. And I like to say insulate yourself a lot. I've said that twice now, I've noticed, and I think the reason I use those terms is I want you as my client to be able to have your business. I don't want you to have to talk to me. Talking to me is not fun a lot of times. I know you don't want to talk to me. I'd love to talk to you about your life and what's going on in my life, but oftentimes when you're calling me, it's because you have a problem. So I want to prevent you from having a problem, the problems are much more severe after you've already done something wrong. So call before you do anything wrong, or have that relationship before you do anything wrong to deal with these ban-the-box challenges.
Yeah, I mean, to piggyback off that, clients that do employment background check, you're being proactive already. So, don't be reactive. Be able to identify the problem before it happens. That's why aligning yourself with, a good employment law attorney and a compliant consumer reporting agency or background screening company will really be able to grow your business and be able to grow with you. So moving on. So in 2012, the EEOC, even when Ban the Box wasn't as popular as it is now, provided a guidance on criminal records used by employers. And what they were seeing, again, was a lot of claims by applicants that they were purely being discriminated against because of having a criminal background. So the EEOC has a lot of teeth. They're very powerful, very aggressive in going after employers on behalf of consumers and employees. So they provided guidance to employers on what they need to look at once they get a criminal record from their employment background screening company. So they stated that if you receive, a felony or misdemeanor record, any kind of adverse information on an employment background check, there's 3 questions you really need to go over with the applicant when discussing the background check or the criminal conviction. The first one is, how long has it been since the crime occurred? Now, we provide 7 years of conviction history. So we provide any felony or misdemeanor convictions within the last 7 years from the disposition date will be reported. So they want to know, was this crime committed last week? Was it committed last year? Was it committed 7 years ago? The second one is the conviction related to the position they're going to have with the company? Now, if the person had a DUI 7 years ago, and they're going to be working on a machine, they're going to be working in the mailroom, they're not going to be driving during the course of their work, they're not going to be on the company's auto insurance, may be a pretty good idea to work with the individual and not disqualify them for that DUI 7 years ago. And the third question is, what has happened since the conviction occurred? Have they gotten multiple problems? Did they not complete the sentencing on that first crime? Are their crimes progressively getting worse? Is there a pattern? So those are kind of the 3 questions that the EEOC really want employers to sit down with the applicant during the pre-adverse adverse action process, and hopefully that's not anything new to anybody on the call. So as you know, if you're going to be making an employment decision based on a background check procured by a background screening company, you have to do the pre-adverse adverse action process pursuant to the Fair Credit Reporting Act. That's basically the applicant gets a copy of their background along with a letter, a pre-adverse action letter stating that adverse information was reported, and they have an opportunity to contact the background screening company to dispute the information if, in fact, it's inaccurate. After 5 business days and the background screening company deems that the background is correct, the adverse action letter is then delivered and the applicant will not be hired. But during that 5 days, it's important on the first day for the employer to say, hey, we received adverse information, this is what we got, and go over those 3 questions with the applicant. And if you want more information on the pre-adverse adverse action process, it's a must. You have to do it if you're doing background checks through a third party, and you're going to be held liable for not giving the applicants an opportunity to dispute the information. So the main component of the law is to wait until, again, a conditional job offer is made before asking about previous criminal activity. I'll also talk about, I can't stress it enough, either the first interview or the conditional job offer. And the main purpose is delaying when asking until further in the hiring process. Getting a good feel for the person, having a good conversation with them, identifying their strengths, identifying the qualifications that they have is extremely important.
So the EEOC guidance on the use of criminal records, obviously that's been since 2012, it's been around for a while. What the EEOC is giving the employers is kind of a nice softball pitch to say, look, after you've not asked them on the application about their criminal history, they look like a good candidate. Then you end up learning that they actually do have something that could be problematic. Well, the EEOC thinks that it would be a good idea for you as the employer, and again, this is probably government at that time, to go through this kind of, I'll use the term loosely, touchy-feely review with the person because, look, we're all human, okay? If you're hiring someone who's 28 years old, and when they were 22 years old, they made some, mistake as a kid. You want to, as a kid's 22 years old, still a kid. You want to explore that with them because you don't want that to be the detrimental limitation on them coming on board. And the reason that you don't want that is because you don't want to get sued by them for saying that you that you violated the law by automatically precluding them from participating in employment. So that's what these guidance factors are. California came up with a comparable system which they called the individualized assessment. That's the Fair Chance Act equivalent, basically, of the EEOC guidance, and this now applies to the 5 or more employee-employer. Again, if you learn something about a criminal history, you need to explore that with them a little bit more to give them the opportunity to potentially be a candidate, because the whole purpose of the Ban the Box and Fair Chance Act is to not disproportionately penalize people who have made a mistake. And as I said earlier on, there's a disproportionately higher percentage of individuals in society who may have made those mistakes, and you don't want to be discriminating against them simply based on the finding of a conviction. So that's what the EEOC guidance and also the California individualized assessment components are.
Thank you, Anthony. You know what, I think we do have, you know what, you want to take a question right now? And not wait till the end? Okay. Sure. So we got, so I recently implemented asking once they have accepted the contingent verbal offer that although marijuana is legal in California. Okay, you know what? Let's get to
We'll get to the marijuana part, and thank you, Yami Gonzalez, for the question, and we will go back to that one in a few minutes when we get to the marijuana part.
Absolutely. Alrighty. I don't want to lose her question.
You know, we're going to transition probably in a moment, so I just want to say to you, if you were in the room with me, I'd be interacting with you and kind of and getting a sense for what do you as a person think about these things. But, you know, I'd also ask, as far as Ban the Box and Fair Chance Act, what's the downside to having these things in place? Well, I think it's pretty obvious. Cody and I were talking about it, but you now have to go through this rigmarole, and you may end up developing good chemistry with the candidate, and he or she may be just a great fit, and they're anxious and you're kind of anxious, and this isn't McDonald's, you're not hiring them to flip burgers, you're hiring them to do a job, arguably a career that they'll retire from, so this is an investment in everybody's time. So you get through a certain portion of this and all of that emotional energy and time, just to find out that they're precluded from participating with you because of some sort of a conviction, even if you do the guidance or the individualized assessment. So you've now wasted your time, and you've wasted their time, and you have to start again. And in the meantime, your business's productivity is falling down and that sort of thing, and there are hurt feelings and that sort of thing. So those are the downsides to ban the box. However, that it doesn't. If it's a law in your jurisdiction, even if it is a downside to you, you have to comply with it. But certainly that would be something that I would be mindful of if I was hiring someone about this now requirement on me to comply with this law.
Yeah. Okay, moving on. I think we're doing good on time. Another requirement, like Anthony had mentioned, is the individualized assessment. That's specific to the Fair Chance Act in California. And again, considering the nature and gravity of the criminal offense, the time that has passed since the offense, and the completion of the sentence, and the nature of the job sought, again, kind of goes back to the EEOC guidance. We again talk about the additional requirements for the pre-adverse adverse action. Federal law, again, 5 business days, but again, ban the box laws and Fair Chance Acts are all over the place. They could be anywhere from 5 to 10 business days for the applicant to dispute the information. If the background screening company feels that a reinvestigation needs to happen because the applicant did provide compelling documents to contradict the information in the report, they have 15 business days at no cost to the employer to do a reinvestigation, and you have to keep that job open while that reinvestigation happens. Additional notices must be provided based on ban-the-box requirements. So I would make sure that if you align yourself with a background screening company, they have a system where it recognizes where the individual is living based on their address, and providing those additional ban-the-box notices as well. This is kind of the map that I was talking about that we created. We'll be adding much more to this and doing a second revision. Now on to the Equal Pay Act, or salary history ban. So the equal pay for equal work has been around for a while. Equal pay for equal work is the concept of labor rights that individuals in the same workplace be given equal pay. It is most commonly used in the context of sexual discrimination in relation to the gender pay gap. States have implemented laws that seek to eliminate pay differentials on the basis of sex. No size standard based on the employer. So again, like ban the box, this could be affecting an employer with just one employee. And the gender pay gap exists in almost every congressional district according to the most recent statistics from the U.S. Census Bureau. Why this is important now is it ties into salary history bans. Like ban the box, employers can no longer ask an applicant or verify what they previously made because of the gender pay gap. And employers will use the information on what they were paid previously to provide the same compensation with the new company. And you're going to continue to have this gap in pay between men and women. So right off the bat, those employers that are doing employment verifications or engaging a company to do the employment verifications, we've done away with providing the wage earned, because frankly, we cannot, verify wage earned or even ask what they previously made during the interview process. I was talking to Anthony about salary requirements or what they expect to make. And do you kind of want to share with them, if you can ask what do you anticipate you want to make here at the company?
Yeah, so, just a couple things before I respond to Cody's comment there. First of all, I find just the existence of disparity in wages between men and women from the statistics that I've read, I find it appalling. I realize that it is a case-by-case situation, so you may have a man and a woman standing right next to each other, and the woman's earning less, and it's because she did not have as much experience or something like that. But just the statistics that I've seen, I find shocking. And the first thing that comes to mind to me also is the gender pay gap in acting in Hollywood. And maybe it's because my girlfriend's an actress and I live in Los Angeles, But I will just share that I find those kinds of things very surprising. I think that if you're qualified, you should be earning a certain amount of money. So I guess what I'm getting at is, I think the Equal Pay Act is a good thing. I think that it's out there to try and make it beneficial to the person coming on board so that he or she can earn what they're entitled to earn. As far as asking them questions, I think it's obvious that you cannot ask them their prior salary history, but you can ask them what are their expectations for compensation coming on board. And you're kind of walking a fine line there, because you're almost, by asking that question, asking them what they previously earned. Yeah. So this becomes a lawyer dance where you have to be very careful with your wording about how you ask them, and maybe you can kind of volunteer some information. I think this is somewhere in the slides about this is what our general range is for this position. Did you have a chance to look at that, sir or ma'am? And that will then, it's a standard interview. That's going to get them talking about money, which you need to talk about. I mean, they need to let you know that this is the range that they're comfortable with, which is kind of an implied understanding that that's probably what they were earning previously. So you are correct. You are about where your competitors are as far as what you offer for a particular position that person's coming on for. So you can have this discussion with them, but you just need to be careful about how you ask it. You do not want to be accused of prompting them for their prior salary history. And how do you ask them that? I'm not going to give you legal advice about how to do that so much as I will just say be careful, be conversational about it. Again, put it out there about what your company offers as far as a range for the position that they're coming into. I mean, and there's no reason not to do that, because if they're coming on board and you give them a sense for what their range is, and they have an expectation of something much higher than that, well, then you can thank them for their time and you can move on to the next person who's going to be a better economical fit for your company. And Cody and I were kind of joking about, of course, unfortunately for the employer, the downside of the Equal Pay Act, and I will acknowledge this, is if you don't know how much they were earning and then you give them their range and it ends up being like 30% more than what they were earning, they're not going to tell you that. They're going to go home and high-five their husband or wife and say, do you know what happened to me today? And that's an unfortunate consequence of the Equal Pay Act. But it can be a discussion topic.
So, yeah, I think transparency is really important, and maybe even documenting the pay range of the position or even on the job posting. Thank you. So salary history bans, where we're at now. State and local governments are increasingly adopting laws and regulations that prohibit employers from requesting salary history information from job applicants. States have implemented laws that seek to eliminate pay differentials on the basis of sex. So currently right now, and we came up with a salary history ban map as well. So I've become very well in creating these infograph maps. So currently 11 states have implemented laws prohibiting employers from asking or verifying previous wages, and they are California, Connecticut, Delaware, Hawaii, Massachusetts, Michigan, New Jersey, New York, Oregon, Vermont, and Wisconsin. Of course, you see California, New York, Hawaii, Massachusetts, kind of the same players in the game, and this is only going to increase as well, just like Man the Box. Aside from the states, you have 9 counties and cities that have implemented laws prohibiting employers from asking or verifying previous wages, and they are listed here: San Francisco, Chicago, Louisville, New Orleans, New York City, Albany County, Westchester, Philadelphia, and Pittsburgh. So again, if you guys are operating in multiple jurisdictions, it's important to know if you're subjected to any of these salary history bans. So employers, just like with criminal records, may not inquire or ask an applicant what their previous wages were, nor would you be able to verify it on the employment background check. This includes verifying wages as part of the background, and employers should have a pay scale for each position they hire for that they can discuss or disclose to the applicant. Again, complete disclosure and transparency. If men and women are performing the same duties, they must be paid the same. That's the whole objective with this movement. And this does not mean that all employees have to be paid the same wage. Difference in pay are permitted, and any difference in pay must be based on reasons other than sex or gender. Qualifications, experience, education, and things like that. Any professional licenses, things like that. Duties and responsibilities. In some cases, they would consult with their labor attorney, Anthony, and you may ask what the applicant income requirements are. So we just went over that. But again, it's walking a fine line. So how do employers, especially small businesses, comply when they have employees doing multiple jobs? In such circumstances, the employer wants to document the reasons that the employees are doing and what their wages are. This can be done by making sure they have a seniority system in place, which is very important, following a seniority system with no exceptions, putting in place a merit system and actually using it, or by measuring quality and quantity of production and including the results in employee earnings or wage incentive plans for piecemeal rates or commission or anything else. Any other factors or reasons not based on sex. Again, the whole point is not paying men and women differently just because they're a man or woman. In the event an applicant discloses compensation history voluntarily, then the employer may use that information when determining salary as well as verifying the wage as part of the employment background check. So we don't encourage employers to trick applicants into voluntarily disclosing compensation history, but if they do, then they did it voluntarily.
Yeah, so I'll add that this slide that is up right now is a very valuable slide for you out there, and here's why I say that. It gives you some things that you can do, you as the employer can do, so that if there's ever an accusation of a violation of the Equal Pay Act, you have in place guidelines and a record of how it was that you compensated people properly. I realize that, especially if you're a small organization, that extra paperwork and all of this extra, maintenance of these kinds of records can be an onerous burden. I'll use a lawyer's word there as opposed to, it can be a pain in the you-know-what to have to keep these records, but it is valuable to you. And if you contact me and say, we have received a letter from a plaintiff's attorney who's making a demand on us for such and such a person for a violation of the Equal Pay Act, I'm going to say, did you have a seniority system in place? Did you follow it? How did you follow it? Did you have a merit system in place, etc.? And if you can tell me that you had all those things and you can give me all that stuff, then I can write a lawyer letter back to that lawyer and say, go away, okay? Your client's lying to you, okay? She sold you a bag of goods or he sold you a bag of goods, and here's proof that you're not going to win, you're wasting your time, and maybe we'll file a malicious prosecution lawsuit against you. Those are very hard to prevail on. But anyway, the point is, this is a great slide for you to create an evidentiary record that insulates, there's the word again, that insulates you and protects you from claims going forward from the Equal Pay Act.
And it is good on an annual basis to revisit your compensation for each of your positions as well, especially if you're adding duties or responsibility or adding new positions. So on an annual basis, it may be a good idea to do a review of compensation based on your positions as well. All right, now the third head of our three-headed monster, marijuana in the workplace. So as everybody knows, like the other two laws that we spoke about, medical marijuana, recreational marijuana is spreading like wildfire, if you will, and no pun intended for the people in California.
So many puns for marijuana.
So 9 states and the capital of the U.S. have passed recreational marijuana laws. Started by Colorado, Washington, California, to name a few. So right now you have about, a fifth of the states out there have recreational marijuana laws. 30 states have passed medicinal marijuana laws. So almost every single state in the U.S. has a form of marijuana law, either recreational or medicinal. It's only a matter of time before all 50 states jump on board. So the federal government still classifies marijuana as a Schedule I drug. That third topic right there is extremely important. Marijuana, along with, and I was talking with, and Anthony shared with me, along with LSD and heroin
ecstasy.
And ecstasy is considered a Schedule I drug through the federal government. So if you have a 100% drug-free workplace policy in place, essentially someone that tests positive for marijuana would be violating that policy. So a Gallup poll was done in 2017 revealed that 64% of Americans favor legalization and 83% for medicinal purposes. So there's obviously a demand for people to want to use marijuana recreationally and medically. So that's why you're seeing a response by these states passing these laws. Previous administration had directed federal prosecutors not to prosecute. And I think probably
Trump's kind of all over the place about what he's or Sessions, I guess. I mean, I guess they're kind of focusing on other things, but every few months I see kind of a change about whether they're going to or not going to enforce the marijuana laws. The fact of the matter is they're not right now. If I had to give an opinion about it, I'd be surprised if they do. This is a money, folks. Marijuana is a moneymaker. It was prohibited back in the 20s and 30s, I believe, because, actually I can't speak on that, but it was prohibited in the 20s and 30s, and it's a Schedule I drug. And I just want to throw a couple quick facts at you before we switch slides here. Heroin, LSD, peyote, ecstasy, and marijuana are Schedule I. Here's Schedule II drugs. Vicodin, cocaine, meth, OxyContin, fentanyl, and Ritalin. Those are some pretty strong drugs, but those are Schedule II drugs, so they don't even rise to marijuana. Kind of get your head around that. And the last tidbit is Washington, Oregon, California, Nevada, Alaska, Colorado, Maine, Vermont, and Massachusetts are the states, and D.C. are the states right now that have recreational allowable marijuana.
So we're going to have opioid, medicinal, recreational states here pretty soon, too?
Yeah.
That's interesting. Thank you, Anthony. Okay. Medical Marijuana and the Americans with Disabilities Act, the ADA, how to balance zero tolerance and not violate disability laws. So, for example, the ADA prohibits covered employers from discriminating against qualified individuals on the basis of a disability and requires such employers to provide reasonable accommodation. So how do you balance both federal law that states that marijuana is an illicit drug, but also the state that allows consumers to have a medical license to have marijuana because of a specific accommodation they must have? How do you balance being able to provide a reasonable accommodation for marijuana, which, again, is a federal drug? The use of medical marijuana can be essential to an employee's ability to perform his or her job and may be the only workable accommodation for the employee. Safety-sensitive positions. These are OSHA-regulated positions that you cannot have somebody in a safety position be under the influence of marijuana. Then we get into what is considered under the influence or intoxicated. With alcohol, I could be under the influence last night and then this morning go into work and not be under the influence. The difference with marijuana is I could have done it in my off time over the weekend, and I come back to work, they test me, it's going to show up. Now, am I under the influence? Yes. Am I intoxicated? Probably not. So how do you balance that? So Schedule I substance, courts have generally found that employers are not required to accommodate the use of medical marijuana under the ADA or state statutes modeled after the ADA. However, I did talk with Anthony, and there are a few cases out there where state Supreme Court decided that the employer did have to provide an accommodation for a applicant or new hire that had a medical marijuana card. You want to?
Yeah, so, okay. Recreational marijuana is a hot topic. Washington, Colorado, then Washington around the same time, 3 or 4 years ago now, amazingly, have made it legal. So it's the topic du jour. And for employers, it's like, great, are all my employees going to come to work stoned? And what am I going to do? And this is super confusing. I would just like to back it up for a minute and let you know, medical marijuana was first legalized by California in 1996, okay? So that's 16, that's 22 years of medical marijuana being allowed in at least one state, and as is pointed out in the slides, now it's like 30 states and et cetera. And what do we not have? We do not have an abundance of court decisions that are granting these disability claims and reasonable, accommodations interactive process. Is there one in Massachusetts? Yes. That's a state court decision. If you're in Massachusetts, I'll be giving you a certain kind of legal advice. If you're here in California, even though this is, we originally legalized medical marijuana, I'm going to be giving you a completely different advice. And the point is, 22 years later, and this is still not a defined subject matter from a lawyer's standpoint. Is it going to change in the next decade? Yes, because we have recreational marijuana, we have 10 states, probably in 10 years we'll probably have 25 states, maybe more, maybe federally by then, and things will change, yes. But as of right now, even though it's really exciting to talk about, and when you go to Las Vegas you smell pot on the street, and you sure as heck smell it downtown Los Angeles, the fact of the matter is there has not been this light speed change in the law about your obligations as an employer. And one other comment, if you are an employer that has federal contracts, or if you are an employer that is a federal employer, the law is clear for you. This is still an illegal drug, so that's easy. Where it becomes more complicated is if you're a state employer or you are a federal employer but you have non-federal workers and that kind of thing. That's where it becomes more complicated.
The DOT, right? You're regulated by the Department of
Right.
Transportation. You are still subjected to it.
Yeah, that's just easy. I mean, that's an easy answer from me.
They did add opioids to the drug screening panel for DOT. I doubt they're going to take away marijuana. Medical marijuana at the state level. So prescribed marijuana use is still considered an illegal use of drugs that is not covered by the ADA. That may not be the case under all state discrimination statutes. Indeed, some states have enacted laws which may require employers to provide an accommodation. So what we're talking about. That would not impose an undue burden. This is important. That would not impose an undue burden on the employer, otherwise pose a direct threat to the health and safety of other individuals. Courts have recognized employers' duty to accommodate. Again, judicial court held that an employer should have least engaged the interactive process to determine whether an employer's use of marijuana could potentially have been accommodated, and that's the one
Massachusetts case,
yeah.
The Barbudo case.
Yeah, that we were talking about.
Yeah. The next slide kind of goes over the facts of the Barbudo case. Again, that's one case that came out, by the way, last year. So 21 years later, you finally have one decision from one jurisdiction that upholds in a limited fashion an obligation for reasonable accommodation and interactive process. I have these conversations when I go to my transportation conferences around the country, and, employers want to do the right thing. They don't want to get sued. They say, Anthony, what should I be doing? I say, well, it depends on what state you're in. I can tell you, California, New Mexico, and Montana have actually come out and full-on said that there is no reasonable accommodation interactive process obligation. In case those are unfamiliar terms to you, basically what that is if somebody has a known medical disability and they bring it to the employer's attention and it's impacting their ability to do their job, you as the employer have an obligation to try and accommodate that, and you have to talk to them and you have to work with them because perhaps there's something else that could be done for them. But the fact that they have a doctor's prescription to smoke marijuana for a medical condition has only been upheld in Massachusetts in the Barbudo case and maybe one other case. It is of limited impact right now. And I'll just offer one more opinion on that. I think a lot of that has to do with the fact that we're still in this uncharted territory of a conflict between the federal government and the state governments about what's legal or not. I think if the federal government legalizes marijuana, you're going to get a streamlined approach about how to deal with it. But until then, it's going to be piecemeal.
So again, let's just go over that case real quick. So an employee had Crohn's disease and told her employer about her need to use medical marijuana to treat her condition. However, when she subsequently tested positive for marijuana, the company fired her under its zero-tolerance policy, stating that it followed federal law and that it had no duty to accommodate. The court explained that the employer was not at risk of violating any law by accommodating the employee, and that an employee should not have to choose between treating a health condition and keeping a job. But again, this is just the precedent, and it's one case.
I'll add one thing. I'm not sitting here trying to say don't worry about it. I mean, the fact of the matter is you now have a high court in a state that has made a well-reasoned decision. So should you be aware of it, and would I talk to you about it if you were my client? Absolutely. So please don't misinterpret my, dismissal of one jurisdiction. But again, 22 years later, you got one in 2017? Come on.
So what does this decision mean for employers? Employers must now accommodate marijuana use? No, but you just need to be aware that there is case law out there. Review any anti-discrimination law in your jurisdiction where you conduct business. Revise drug screening policy in areas where employers must accommodate medical marijuana use. That's still not out yet. And it should be clear that employers will not take an adverse employment action based on a positive test for medical marijuana used in accordance with applicable law, if there's the law is out there. All right, some takeaways. I want to leave some time for questions and then also address Yami. So confirm compliance with state and local laws, ban the box. So if you guys are in a ban the box or Fair Chance Act jurisdiction, eliminate the question on the application. Figure out if it's a law that you can provide a conditional job offer first, or can you ask during the first interview. Confirm compliance with pay equity laws. Also going back to the ban the box, if there is a special individualized assessment clause, make sure you're applying that, making sure you're applying the 3 questions. Is this crime specific to the job they're having? How long has it been since a crime occurred, and what has happened since then? So with confirm compliance with pay equity laws, don't inquire about previous wages or salary at any point, whether it's on your background check or in person. Don't verify those previous wages on the background check. Again, do a compensation history review. Making sure that you are paying men and women the same if they're doing the same duties and responsibilities. It's pretty simple. Confirm compliance with state medical recreational marijuana laws like we just talked about. Update your drug screening policy if you don't already have one. And remember, again, federally, it is still an illicit drug. So that's kind of what we have. Anthony, do you want to give them your email address and contact information? This recording is going to be on our webinar page on our website in 48 hours. I could also send the PowerPoint presentation to anybody that wanted to attend, but I want to make sure you guys get Anthony's contact information because I do apologize. I failed to put it on here, and Anthony, don't beat me up, for that.
Later, Cody.
So do you want to give your information
Yes.
now, and then I'll also email it out? Go ahead.
So thank you, Cody, for that. And you could, of course, if you don't catch this, you could just email Cody and ask for it. But it's Anthony.McLaren, ANTHONY.MCCLAREN @ADLILAW.com. Anthony.McLaren@adleylaw.com. That's probably the best way to get in touch with me. Please send me an email. I'd love to hear from you.
All right. So let's get back to Yami's question.
Okay.
So I recently implemented asking once they have accepted the contingent verbal offer, good, you're giving the conditional job offer, good, that although marijuana is legal in California, we go by federal law and will disqualify them on the drug test if positive and should they have any concern. Is that okay?
Okay, I know you're not in here I'd ask you a couple follow-up questions. I'm going to make a couple assumptions here. First of all, I think that you are in California.
Yes, she is.
So if you have an existing drug policy and you apply it across the board, then you are generally okay to follow whatever your drug policy is. So if your drug policy follows federal law, which is that marijuana is illegal, then you can enforce that against them. So you say after you let's see, I recently implemented asking once they've accepted contingent verbal offer that although California is legal, marijuana is legal, we go by federal law and we'll disqualify them on the drug test if positive, and should they have any concerns. Yes, I think that that's okay. My reaction to that, of course, with a lawyer's reservation, of course, would need a little bit more information, but I think what you are doing is legal as long as you have in place a defined drug policy that you consistently apply across the board, which basically says that if you're going to work for us, it's zero tolerance here. And if that's a problem with you, well, then you can't work for us. That's okay. I will comment briefly that depending on which state you're in, and I think California is one of them, if you are an employer and you desire to create a drug testing policy and you previously did not have one, or if you have one and you want to change it, you need to contact your attorney to let you know about how to go about properly changing it or making one. So the law generally is if you had one in place already before recreational marijuana became legal, then it is acceptable. But if you want to make a change to it or if you want to create a new one, depending on which state you're in, there are certain obligations that you as the employer need to adhere to. But to answer your question, generally speaking, yes, I think that what you're doing is okay.
Thank you, Anthony. Do we have any other questions? I didn't get any emails yet. You could utilize the chat feature. My email address is here. And, of course, please feel free to email us offline, and you have Anthony's contact information as mine as well. Also, if any of you have any topics that you want to hear on related to, background checks or employment law in general, we're planning on doing a lot of these throughout the year. But we really want to know what you guys, our attendees, want to listen to. So email me anytime, email Anthony anytime about any topics you want to hear. We're almost out of time. I want to thank Anthony for joining us, making the time to come all the way from downtown LA and making himself available. We look forward to our next webinar. And again, this recording will be available on our website, on our webinar page, in about 48 hours. So if there are no other questions, again, thank you, Anthony, and thank you, everybody, for joining us. You have a wonderful day.
Thank you, Cody, and thank you, everyone.